Unit 2, Presentation 5, the possible outcomes of parole hearings. There are three main possibilities: a refusal, a rehearing, or a grant. A refusal means a person will not receive any further parole hearings. The effect is that she will serve her sentence until her mandatory release date. Generally speaking, if a person is not refused parole the first time she goes up, but instead receives a rehearing, she won't be refused at subsequent hearings. This is because of the principle that if the nature and circumstances of the crime, a static factor, was not a reason to refuse a person the first time around, it ought not to be a reason to refuse her the second or the third time around. After all, nothing could possibly have changed as regards the past. However, given that there are 10 commissioners and many more hearing officers who have broad discretion in weighing up factors, it is possible that a subsequent commissioner will take a different view to a previous commissioner. In addition, if a person has had a particularly bad infraction record since the last hearing, or has completely failed to comply with recommendations made at a previous hearing, it is possible that she will be refused that time round. If a person is refused parole, all is not completely hopeless in terms of an opportunity to be released earlier than her mandatory release date. 2 years after she has been refused, she may write to the Parole Commission requesting that decision be reconsidered, i.e. requesting a subsequent hearing. A letter requesting a rehearing should, and I'm quoting here, set forth any new facts, conditions, or circumstances not previously considered by the Commission. Notice the word new in that regulation. If you're writing a letter like this, try to make the focus of the letter things that weren't considered before, or at least an angle which wasn't considered before. The letter will be passed to the decision makers who previously decided the case. They may schedule a rehearing or deny a rehearing. If they choose to deny a rehearing, the details for the denial have to be set forth in writing and served upon the person. If the rehearing is denied, after another 2 years have passed, it would be open to the person to write again, asking for a rehearing. Once again, any new facts, conditions, or circumstances which might change the outcome should be set out in the letter. Rehearings. So one possible outcome of a parole hearing is that a rehearing is scheduled at a specified point in time. This is usually a number of years, the most common being 2, 3, or 4. In colloquial terms, having a rehearing scheduled for, say, 2 years' time is known as getting a 2-year hit. Where the outcome of a parole hearing is the scheduling of a rehearing, the hearing officer, or as the case may be, the parole commissioners, will set out in writing what areas and issues an inmate should work on in the intervening years in order to be successful next time round. When it comes to the rehearing, be sure to specify very clearly in your parole packet the ways in which you have acted upon those recommendations. Now, it may be the case that it was not possible to fulfill some of those recommendations. For example, perhaps it was recommended that a person take part in a particular course or program, but it turns out it wasn't available at the institution, or the person didn't qualify for it, or the best the person could do was to get on the wait list for it. Even so, those efforts should be documented in the parole packet. There are definitely things that are out of people's control, and the Parole Commission will recognise this. The important thing when a rehearing is scheduled is to show best effort to respond to whatever was set out in the previous decision. The most positive possible outcome at a parole hearing is a grant. In most cases in which parole is granted, there will be a delayed release specified. Recall that first-time round parole hearings happen about 6 months before parole eligibility. So in those circumstances, release would have to be delayed anyway. Delayed release can entail a delay of quite some time, sometimes as much as 2 or 3 years, although it could also be shorter. For some people, a delayed release date can end up being very close to their mandatory release date once the good time they are yet to accrue is factored in. This can lead to a sense of frustration and disappointment that their early release through parole is hardly early at all. Nevertheless, a grant of parole, even with a delayed release, provides a clear view of release on the horizon. Even when parole is granted but a delayed release date is not specified, release does not occur immediately. Two important things have to happen before the person is released. Firstly, the parole order has to be presented to and accepted by the person. It is essentially a contract which sets out the terms and conditions of parole. There are standard terms which will be in every parole order, and then in some cases there are specific terms which the Commission places on a particular person. Examples are to not contact a named victim, to not drive, or to attend certain classes. The chairperson of the Commission files a copy of the parole order with the clerk of the court in which the person was sentenced. It is the parole order which entitles the person to serve out the rest of her sentence outside of prison, provided she complies with the conditions. So the other thing that would have to happen before release is that the parole plan, and most specifically the home plan, will be checked out. COMAR states that a person may not be released without an approved parole plan. It is the Department of Parole and Probation which checks out home plans. It is case management which is responsible for telling the Department of Parole and Probation what a person's home plan is. So, if you are going up for parole, and even more so if you have been granted parole, be sure your case manager has the correct details of the home plan. It has been known, for example, for one digit on a family member's phone number to be wrong on the home plan, and that kind of thing could lead to a delay in the home plan being confirmed, and the result would be a person spending more days in prison than she otherwise would have done. If there is an issue with the home plan, the Department of Parole and Probation will contact case management to request that a new plan be submitted. So, when you're preparing for a parole hearing, it is worth thinking about what a backup home plan might be, should the primary home plan for some reason or other not work out. If a grant of parole does not specify a deferred release, COMAR states that release should happen as soon as practical. Furthermore, COMAR provides that it is the policy of the Commission that an inmate who has been approved for parole may not be incarcerated for more than 30 days from the date of the approval. The regulations also state that the Commission must be notified in writing if anyone is being kept 30 days after that date. In practice, such a delay could be attributable to things like a detainer on a different offence which hasn't been dealt with, an outstanding arrest warrant, or an immigration issue, or the lack of an approved home plan. Two important things to be aware of. A person who's been granted parole but has not yet been released should focus on maintaining good conduct in prison. Because if they don't, the warden has a responsibility to inform the Commission, and the Commission might then opt to cancel the parole order. And the second thing is that after release, when the person is subject to parole supervision and they have to comply with the terms and conditions of the parole order, if they breach one of those conditions, there's the risk of being brought back into prison. But for that to happen, there has to be a hearing, a parole revocation hearing, it's called. Now, if you're facing a parole revocation hearing, you need to get a lawyer. The regulations actually provide that the Parole Commission should do their best to find a lawyer for someone who is indigent, who's in that situation. But the point I'm trying to make here is that there's a big distinction between a parole hearing itself, when it's good to have a parole advocate, you don't necessarily need to hire a lawyer, and a parole revocation hearing, when you need to hire a lawyer. So a couple of other possible outcomes of a parole hearing other than the three main ones. One of them is administrative refusal. And that occurs when a person is refused not on the substance of their bid for parole, but because there's some other reason that it simply wouldn't make sense to have a parole hearing at that point in time. An example would be if someone's facing a detainer on another charge, which would mean that they weren't able to be released anyway, because once they're done with the conviction to which the proposed parole hearing would relate, they'd still be detained anyway on another matter. So you'd get an administrative refusal in that scenario, so the person can focus their time on addressing whatever that underlying issue is before doing the parole hearing. But one point I would make is that even if you have other underlying legal issues going on, it is worth having a mindset of being focused on parole hearing preparation, because if the detainer or the other charge is taken care of, you could find that you very quickly you've reached parole eligibility, and now whatever the barrier in the way was is no longer there, and so you're up for a hearing very quickly. So it makes sense to have been working on the parole packet throughout the time that you were addressing the other matter. And the other thing that could arise is a deferral or a hold. And that is often when some other further information is required. And so the thing will be put on hold while the information is got. And an example there, the most common one of those would be people with life sentences who are sent for a psychological assessment before the Parole Commission decides that they are going to recommend that person to the governor. So their parole hearing process will be put on hold while that happens.